welcome to the third video in our series, Unpacking the Key Rules and Requirements in relation to cost budgeting. Today we look at what happens after that budget has been prepared. So once you've prepared your budget prior to getting to a cost management conference when the court will deal with that budget, what else happens? Well, if we go to CPR 3.13.2, we'll find a requirement in relation to budget discussion reports. It provides that in the event that a party files and exchanges a budget under paragraph 1, all other parties not being litigants in person must file an agreed budget discussion report no later than 7 days before the first case management conference. So budget discussion reports are provided in precedent R, or at least the parties are encouraged, pursuant to the provisions of paragraph 6A of PD3E, to use the precedent R budget discussion report, which is next to the practice direction. The budget discussion report itself is a document which, per Rule 3.13.2, must set out the figures which are agreed for each phase, the figures which aren't agreed for each phase, and a brief summary of the grounds of dispute. The precedent R itself looks like this. I appreciate again that that's probably quite difficult for you to see on this screen. I'd encourage you to go onto the Court Service website, Practice Direction 3E, and familiarise yourself with the precedent R. So, as with all matters, the court wants to see parties being pragmatic, proactive, trying to resolve issues and disputes between them without the need for the court to get involved. So making a good analysis of the reasonableness of your opponent's costs. Once you come to set out your objections to their cost within the precedent R, to their budget, then do make sure that you make offers, make sure that you make cogent and brief, concise submissions. So what happens at the CMC? What are the court's powers at the CMC? What is it that it's going to be doing? We've already flagged up and discussed briefly that tension between incurred and estimated or future costs. Again, it's something that we'll come back to in more detail when we're going through case law, which has shed an amount of light on the provisions we'll now look at. But for our purposes today, by way of this brief introduction and an unpacking of the key rules and requirements, we look at paragraph 7.3 of PD3E. If the budgeted costs or incurred costs are agreed between all parties, the court will record the extent of such agreements. Insofar as the budgeted costs are not agreed, the court will review them and, after making any appropriate revisions, record its approval of those budgeted costs. I flag up again, as we have done in the previous video, the indication this gives of the court's powers when dealing with budgeting. To the extent that budgeted costs are agreed between all the parties, then the court's going to record the extent of that agreement. It should only be getting involved in concerning itself with the aspects or elements of the budget which aren't agreed. Just to be clear, by that I mean that to the extent that phases aren't agreed completely, then the court will want to and be able to interfere with those. So it won't be sufficient, for instance, to say, well, the expert's fees in the expert report phase are agreed, but all the other elements of it remain in dispute. In that situation, the court is going to be able to look at the entire phase and ignore anything that you might have agreed in relation specifically to the expert phase. If you have an element of a phase which isn't agreed, the court will have power to determine that phase as it sees fit. The court's approval will relate only to the total figures for budgeted costs of each phase of the proceedings, although in the course of its review it may have regard to the constituent elements of each total figure. Again, the costs which you project will likely include counsel's fees, expert fees, will likely include the amount of time that you expect to be spent in the future and the hourly rates that will apply to it. So whilst the court likely will want to look at those details and those component elements of the cost budget itself in order to form a view as to whether the phase is reasonably proportionate, fundamentally it is looking at those overall phase totals and is budgeting by phase. So not just budgeting as a whole and giving you a lump sum for the entirety of your budget, not being required to, and probably out with the rules if it did, to go through each element of your budget and give you a specific number of hours, for instance, or a specific hourly rate. It has to and does budget by overall phase totals. That said, if it uses the component elements to reach that overall and reasonable phase total, then I don't imagine there really be any reasonable criticism of that, as long as it still fundamentally was setting phase totals rather than trying to restrict individual elements within phases. Paragraph 7.3 of PD3E carries on that when reviewing budgeted costs, the court will not undertake a detailed assessment in advance, but rather will consider whether the budgeted costs fall within the range of reasonable and proportionate costs. Pausing there, at all stages the court is considering on a fairly global and top-down basis whether costs fall within a reasonable and proportionate range. A range is, of course, exactly that. Sometimes figures may fall at the lower end of a spectrum, sometimes towards the higher. You're trying to justify the assertion that it falls within that range at all so that the court can approve it. The reference to not undertaking a detailed assessment in advance is fairly pragmatic. There will not be sufficient time, in all likelihood, in the context of a cost management conference to devolve into the kind of detail that's seen on detailed assessment. It's unlikely to be able to put before the court the extent of documents which you tend to see on a detailed assessment and which judges would often want to see in order to be satisfied as to the reasonableness and proportionality of costs. We are making the best of this situation. We have to be pragmatic and try and work within the confines of the rules. So whilst the court won't be undertaking a detailed assessment, it will still be necessary to make submissions as best we can in order to justify the costs and show and demonstrate to the court why it is that those costs are necessary and why it is that certain aspects of the litigation might be thought to take you down a route which might be more expensive than your opponent plans for, or more expensive than that which the court ordinarily tends to see. What about incurred costs? Again, this is a large battleground. The court doesn't approve incurred costs. Per paragraph 7.4 of PD3E, as part of the cost management process, the court may not approve costs incurred before the date of any cost management hearing. The court may, however, record its comments on those costs and will take those costs into account when considering the reasonableness and proportionality of all budgeted costs. That is a difficult provision to work with, so it doesn't assess the incurred costs and it doesn't control them in any way. It can make comments on them, but it will take those costs into account when considering the reasonableness and proportionality of all budgeted costs. How do we deal with that in practice? You will be dealing with budgeting at a hearing probably of an hour and a half, 2 hours. In some cases, you may have many thousands or hundreds of thousands of pounds that have already been incurred, which in the context of a short hearing, it may be difficult to get a court or a judge to accept that those costs in and of themselves are reasonable or that they shouldn't impact upon the future allowances. That is a difficult and problematic area, and again, is something that we'll come back to in later videos in this series. So again, just to flag up at this stage, while we're still in the early stages of these videos, that rule exists, that it does create problems, and it is an issue that we all have to be alive to. What about hourly rates as well? Because we've already said that the court budgets by overall phase totals, though it may have regard to the component elements of the budget. Hourly rates are a hot topic. There have been various cases looking at hourly rates in the context of budgeting and what implications that has for detailed assessment. Fundamentally, though, per paragraph 7.10 of PD3E, the making of a cost management order under Rule 3.15 concerns the totals allowed for each phase of the budget. It's not the role of the court in the cost management hearing to fix or approve the hourly rates, but the underlying detail in the budget for each phase used by the party to calculate the totals claimed is provided for reference purposes only to assist the court in fixing a budget. So fundamentally, the court isn't assessing or determining the hourly rate that you will later recover on detailed assessment. Again, though, being pragmatic, trying to engage in this in a real world context, it's likely that the court is going to want to look at your hourly rates. It may be that in the context of a costs and case management conference, that you need to address them in some way. If, for instance, you have what your opponent says are very high hourly rates, you might find it necessary and desirable to address with the judge why, in actual fact, whilst they're not setting your hourly rates, the court ought to be approaching budgets on the basis that an hourly rate in the order of whatever you're claiming in the budget is a sensible and reasonable way in which to plan and estimate those costs. What happens after the CMC? Well, per paragraph 7.7, after its budgeted costs have been approved or agreed, each party shall refile and reserve the budget in the form approved or agreed with recast figures next to the order approving the budgeted costs. It's, I think, probably an often overlooked step. It is important to make sure that you do refile and recast your budget. There are various instances in which courts will dispense with this particular aspect, just setting out the figures themselves within the order. We would still recommend in all circumstances that your amended budget is filed and served in order to make sure that there aren't any errors in relation to the order or the amount of the order, and to make sure that everyone is very well aware of the individual face elements. It's common in orders that recite the amounts of the parties' approved budgets to just do that by the overall total without breaking down that figure into phases. So do make sure that you comply with this, and you will thank yourself in the long run. Skirting back then to those paragraphs and provisions in relation to revision of the budget. Again, we do no more at this stage than flag up the fact that there is a facility for budgets to be revised and amended later. We'll go in more detail in later videos and sessions as to how those provisions operate and how parties can best place themselves in order to maximise their chances of varying the budgets when they need to. That concludes the third video in our series. I look forward to presenting to you again. Stay safe.